Why medieval law was weird, boring history for sleep asterisk. Allow yourself to slip quietly back into a world of smoky timber halls, thatched cottages, and winding muddy roads, a place where justice is rarely swift, never uniform, and often more confusing than reassuring. In medieval Europe, the idea of law did not mean a single code, but a bewildering patchwork of customs, royal decrees, church edicts, and ancient traditions. Here, to live even a simple life was to be tangled in a web of rules and rituals whose logic often eluded everyone, sometimes even the judges. Imagine you were a villager in 13th century England, perhaps a farmer or a weaver, waking to the tolling of the church bell. For you, law is not written in books on a magistrate's shelf, but embodied in people, the local reeve, the village priest, the landowner's steward, and, above all, the community. Justice is something negotiated in the open air, in the shadow of the manor or under the spreading branches of an ancient oak. There are so many rules, but they change from valley to valley, even from village to village. In one hamlet, a pig that wanders into a neighbor's field must be returned with an apology. In another, the animal might be forfeit to the lord as a stray. Theft of a loaf of bread is a hanging offense in the king's town, but only a day in the stocks in a distant shire. Custom is king, and every custom has its exceptions. For serious crimes, justice is both highly public and deeply personal. Accusations are shouted out in front of the whole community, and the guilt or innocence of the accused may depend as much on local reputation as on evidence. Witnesses are scarce, and memories are short. A clever tongue can sometimes carry more weight than hard facts, especially if the accused is well liked or feared. The machinery of justice is as complex as it is inconsistent. Manorial courts, run by the local lord or his bailiff, handle most everyday disputes, trespass, debts, minor assaults, or arguments over inheritance. Here, cases are heard at irregular intervals, and the outcome often depends on who has the ear of the lord or the loudest supporters in the crowd. Fines and forfeitures are common punishments, usually paid in coin, chickens, or labor. The system is not entirely arbitrary. There are records kept on parchment rolls, and a sort of rough fairness is expected, especially in small communities, where everyone knows everyone else. But not all justice is so local. For more serious matters, murder, arson, major theft, the king's law, or common law, takes precedence. Royal judges, called justices in air, travel the countryside, in grand circuits, dispensing the king's justice at periodic assemblies. Their arrival is both exciting and terrifying. Banners fly, trumpets sound, and the townsfolk crowd the market square. Cases are called in public, and the punishments are severe hangings, whippings, or mutilations, meant to warn others. If the accused claims innocence, and no clear proof is available, the medieval world turns to ordeal. Ordeals are strange, ritualized tests, plunging one's hand into boiling water to fetch a stone, walking across burning plowshares, or being bound and thrown into a river. The idea is that God will protect the innocent. The wounds are bandaged, and after 3 days the injuries are inspected. If they have healed cleanly, the accused is declared innocent. If not, guilt is presumed. Church and crown sometimes disagree on these matters, but both rely on the belief that divine judgment trumps human error. There are other, equally odd customs. The hue and cry is raised whenever a crime is discovered. All able-bodied men must join the chase. Failure to do so is itself an offense. If a thief escapes and the village cannot produce him, the entire community may be fined, a concept known as frank. For those with means, trial by combat is another option. The accuser and accused fight, often with clubs or swords, until one yields or dies. Victory is taken as a sign of God's favor. The church, too, has its courts, ecclesiastical tribunals, that handle sins of the soul, marriage disputes, heresy, blasphemy, and the like. Punishments here are different: penance, pilgrimages, excommunication. Sometimes, these overlap with secular matters, and confusion reigns. A murderer might seek a sanctuary in a church, safe from arrest for 40 days. At the end of that time, he must abjure the realm, confess, leave the kingdom, and walk to the nearest port, never to return. Beneath all this formality, the realities of enforcement are often mundane and inconsistent. The village constable may be elderly or corrupt, the lord distracted or absent. Many crimes go unpunished or are quietly settled with compensation and a handshake. Fear of vengeance is real. Feuds simmer for generations, and blood money wurgled is paid to prevent open war between families. To the outsider, it may seem chaotic or even cruel. Yet for those who live within its bounds, medieval law is a constant, sometimes comforting, sometimes terrifying, always woven into the rhythms of daily life. Justice is slow, imperfect, and sometimes arbitrary, but it is also a vital thread holding society together. As you close your eyes, let the mutter of voices, the rustle of parchment, and the clang of the village bell fade into the distance. How did people navigate this world of uncertainty and ever-shifting rules? What did it feel like to stand accused, to plead for justice, or to try to right a wrong when the very idea of right was always up for debate? Imagine, for a while, your life as a tenant farmer or a small-town merchant in the later Middle Ages. The rules that shape your world are not found in a single book or posted on the town gate. Instead, they flow from a tangled mix of custom, oral tradition, proclamations from the local lord, and the shifting pronouncements of the crown. It's a daily reality that's less like reading the rules of a board game and more like playing a never-ending match in which the rules change every turn, sometimes without warning. If you're unlucky enough to be embroiled in a dispute, you quickly learn that legal knowledge is rare and specialized. Only a few men, perhaps the local priest or an itinerant notary, can read and write well enough to draft a formal petition. The rest must trust memory and the weight of precedent, hoping that elders and neighbors remember past cases and agree on how they were resolved. For many, justice is as much about performance as fact. You speak well, present your case to the crowd, and hope for their sympathy. You might be summoned to a manorial court to settle a boundary dispute with your neighbor. The session is held on a wooden bench under the open sky, or inside a drafty hole thick with the scent of rushes and livestock. The Lord's steward presides, his patience as thin as his authority. He listens to both sides, consults the ancient court rolls, and perhaps calls on witnesses who remember the field in question from their childhoods. Sometimes, the court decides to view the land, trudging together to the disputed hedge or stream. The verdict may be swift or may take weeks, depending on the mood of the Lord, the importance of the disputants, and whether anyone brings gifts or favors to smooth the process. Fines are the usual punishment, modest for the well-liked, steep for those who cannot plead their case or are new to the village. Payment is made in coin, goods, or work, a few hens, a piglet, or a week spent repairing fences or mending roads. If you're lucky, the dispute ends with little more than a handshake and a stern warning. If not, grudges may linger, simmering beneath the surface for months or years. Crimes of greater consequence, cattle theft, arson, or violence bring heavier burdens. Accused parties may be locked in a makeshift holding cell or confined to the stocks, exposed to the mockery and sometimes the rotten vegetables of neighbors. Local gossip becomes a secondary trial, and a bad reputation can ruin a person's prospects long before any verdict is delivered. If the royal justices arrive, the entire village is appended. Banners flutter as the court sets up in the churchyard or market square. Every able-bodied man is summoned for jury duty, though the idea of a jury is still evolving. The jurors, drawn from the community, are meant to know the parties and the facts. They may be influenced as much by old resentments and alliances as by evidence. The procedure is formal but deeply strange to modern eyes. After the charges are read, the accused may be asked to plead, or may be put to the proof. Ordeals, though increasingly rare by the 13th century, still echo in the legal process. Sometimes the case is decided by compurgation. The accused swears an oath of innocence, then assembles a group of oath helpers, friends and neighbors who swear they believe him. The more serious the crime, the more oath helpers required. Reputation is everything. A person known for dishonesty may not find enough willing to back him. Some take refuge in the church, invoking sanctuary. This is both a legal and spiritual maneuver. The accused is granted temporary safety, usually 40 days, during which time negotiations may take place. Sometimes, the accused confesses and is exiled. Other times, a settlement is reached, or the culprit slips away in the night. The church courts, meanwhile, buzzed with their own cases, charges of adultery, blasphemy, heresy, or disputes over wills and marriages. Ecclesiastical law is written in Latin and interpreted by educated clerics. Penances can be creative, a pilgrimage to a distant shrine, the public recitation of prayers, or standing barefoot before the altar in midwinter. Some cases spill over into the secular courts, especially when church and state disagree about authority or punishment. Women, children, and outsiders face a complicated legal landscape. Their testimony may be discounted, their access to courts limited, and their punishments shaped by local prejudice. Sometimes, the very strangeness of the law can be a shield. Jurors may hesitate to condemn a widow or an orphan, or the Lord may pardon an accused poacher for lack of clear proof. Most people, however, want to avoid the courts altogether. Disputes are more often settled at the tavern or at the church door, brokered by elders, priests, or neighbors with a knack for compromise. Compensation rather than punishments is the norm. A broken fence can be mended, a stolen chicken returned, a slight repaid with a pint of ale or a gift of eggs. Yet, for all its confusion, the legal system does evolve. Over the centuries, records become more detailed. Written laws begin to circulate. Kings and councils issue statutes that try to bring order out of chaos. Still, the process is slow, halting, and always imperfect. Local custom, personal reputation, and luck remain as powerful as any royal decree. As dusk settles and the village bell tolls the curfew, the daily noise of disputes fades. Tomorrow, new cases will be heard, new oaths sworn, and the patchwork of law will grow a little more intricate. What happens, though, when the system fails entirely, when the law cannot resolve a feud, or when justice is seen as a tool of the powerful? How do people adapt, resist, or seek redress outside official channels? as the centuries roll onward and the fields ripen and wither in their endless cycle. You might notice that the oddities and inconsistencies of medieval law are not simply quirks. They are the ground on which daily life is played out, yet every system, however patchwork or deeply rooted, has its limits. What happens when law fails to keep the peace, or when its arbitrariness becomes a source of suffering rather than order? You might witness, in your lifetime as a villager, the slow chafing of repeated injustice. A Lord Steward grows greedy, levying extra fines and ignoring traditional limits. Perhaps the king's justice is too distant, too expensive, or simply too preoccupied with matters of state to address local grievances. Feuds flare when mediation breaks down. Families feud for generations, trading insults, blows, and sometimes deadly ambushes. In some places, banditry and vigilante justice become the only recourse for those left outside the law's protection. Peasants and townsfolk sometimes band together, resisting what they see as unlawful taxes or oppressive decrees. In 1381, for example, English villagers rise in the famous Peasants' Revolt, fueled by anger at poll taxes and the inequities of the legal system. They march on London, burning manorial records and demanding reforms. The rebellion is suppressed, but not before it shakes the foundations of royal authority and forces a reckoning with some of the harshest aspects of feudal law. Reform does come, if only slowly. As written statutes multiply, monarchs and parliaments begin to impose more uniform rules, sometimes in response to unrest, sometimes to strengthen their own control. The Magna Carta of 1215, wrung from King John by a coalition of nobles, guarantees certain rights and limits royal authority. No free man shall be seized or imprisoned, except by the lawful judgment of his peers or by the law of the land. This phrase echoes down through the centuries, a distant promise of a more predictable justice. In the towns, the rise of merchant guilds and city charters brings new courts and new rules. Citizens take pride in their own brands of order. City watchmen patrol the streets, apprentices swear loyalty oaths, and burghers elect councils to settle disputes. The slow growth of literacy means that more people can appeal to written law, not just custom or memory. The church, too, evolves. As heresy and dissent spread, inquisitors develop more elaborate procedures for trial and investigation. Harsh, often meticulous, pilgrimages, penances, and pardons become both spiritual practices and legal tools shaping the lives of the faithful. Yet, for most, justice remains a negotiation. An unjust verdict can be appealed sometimes to the king, sometimes to the pope, sometimes to the court of public opinion in the marketplace or at the churchyard gate. Songs and tales are spun about clever villagers who outwit greedy bailiffs or corrupt judges, and these stories circulate from one end of Christendom to the other, comforting those who live under the shadow of arbitrary power. For the unlucky, exile is the ultimate punishment, banished from the land, name erased from village memory. Others, though, are remembered as troublemakers, rebels, or folk heroes, their defiance living on in legend. Over time, the seeds of change take root. Customary law evolves into written codes. Trial by ordeal gives way to trial by jury, and the ideal of justice for all flickers to life, however faintly, that as you settle into sleep. Consider how far the world has traveled from those muddy, crowded courts and anxious gatherings under the oak tree. The peculiarities of medieval law may seem distant and strange, but their legacy lingers in the rituals of our own courts, the language of our rights, and the enduring struggle to balance order and fairness. Every system of justice, however imperfect, reflects the fears and hopes of its people. The villagers, lords, priests, and wanderers who lived by these weird rules left behind more than parchment and records. They left the slow, stubborn belief that justice, in all its strangeness, is worth pursuing.